Morning, everyone. So today we'll be discussing about data breach notification. In case there's a data breach, how organizations should respond to. So data breach notification has like two parts. So either you notify the regulatory body, or the regulatory body can come back to you. There is a data breach or there is a privacy breach. So we'll be discussing it on both ends. So about Tsaaro. So Tsaaro, guys, it's a boutique consulting firm. We help organizations comply with the data privacy regulations and security standards. We also indulge into trainings, various people. So you will see various courses being floated. So this is what we do. And as for the speakers for tonight, it's me. So I'm Rohit. I am a director of solution implementation at Tsaaro. I am a CIPM and Azure Solution Architect. So I can understand technology, I can understand privacy. We also have Ujwal. So I'll let Ujwal introduce himself. He's a very senior privacy professional.
Thanks, Rohit and entire Tsaaro team. So first, let me introduce myself. Myself, Ujjwal. I'm based out of Kolkata, the city of joy. I am a privacy lawyer working with private clients, advising them on various implementing their policies and doing their incident response plan, preparing the incident response playbook, so on and so forth. So today we are going to discuss on the two parts mostly. The part one is going to breach notification, and part two is going to be an enforcement order, which rather it's a live example of a ICO order, and we are going to do some sort of dissecting that order so that the privacy professionals, the privacy enthusiasts who had gathered on this winter morning today, just you can have a look that how paradigm of enforcement or imposition of administrative fine, how that is taking a shift. So this had been our line of thinking when we were planning for this webinar.
So disclaimer, guys, all the things that we discuss is basically for educational purposes. We do not represent the organizations that we work for. On the agenda, we'll be discussing, as I told you, we'll be discussing about data breaches, how and when the data breaches have to be reported, what are the certain guidelines given by certain Indian body, by GDPR. We'll also discuss an example where breach notice was given by one of the data regulatory bodies to one of the organizations, and what was there, what was the content of it. So today we'll be discussing that. We'll start with what is a data breach. So I think so Ujwal has very interesting thoughts on this, and what is a data breach and what cannot be a data breach. I think so we should discuss both of them.
So thanks, Rohit. We all know about this, personal data breach, which is already has been coined as a definition in the GDPR. What comes to our mind is this: the draftsmen of the GDPR, they have very consciously made a personal data breach something which is a real incident, that is an anticipated data breach or an anticipated pilferage of data that has been brought beyond the definition of the personal data breach as made in GDPR. Exact definition of the data breach or the personal data breach that says a breach of security leading to accidental or unlawful destruction, loss, alienation, unauthorized disclosure of access to personal data. So there need to be an actual threat, actual damage for which users of the data, they can't access a hospital database or patient database kept by a healthcare institution for, say, for example, for four hours. Now that is not going to be data breach, though at that point in time the people, they want to access the data, they are unable to collect the data. That might have given some real challenges to them, that might have also had caused loss to them, but that is not, at least under the GDPR, going to be considered as a data breach. So under GDPR, what you find that data breach need to be something which need to be actual, the actual damage, actual loss, no anticipatory. So that we find a very salient or very fundamental aspect of data breach.
This is a very, very interesting point that you've said. So moving ahead, guys, in India, do you think, because we do not have a privacy bill as of now, we do not have a data protection bill, do you still think that we have to notify some authority or report some authority of data breaches? Should it be done in like 24 hours? If you move ahead, if you see that there's a body in India called cert-in, which is mostly for security responses. These guys have made it mandatory that the data breaches in India should be reported within 6 hours. I would let Ujjwal compare both of them.
Yeah, no, it's a very good point that way. In fact, I will say that cert-in, that is Computer Emergency Reporting Team, and the authority is cert-in authority under the Ministry of MEIT. So that's a more broader, according to me, a broader principle or a broader legislation in comparison to GDP. Data breach and data leak are two distinct reportable items under the cert-in, but there are other items like, say, for example, targeted scanning or compromise of the critical system and information, defacement, intrusion, unauthorized change of website, or identity theft, spoofing, and phishing attack. So they do all fall under the search. And data breach and data leak are also there. The particular data incident is falling under that parameters which the cert-in has already defined, and then our responsibility or liability to make the reporting comes. So it might happen that it is not going to be 6 hours absolutely from noticing, rather 6 hours once we determine, or once the concerned team determines that yes, this is a reportable incident breach. So it might happen that if you see that from noticing a breach or noticing this kind of security incident, say 24 hours time is required to identify that yes, this is something which is a reportable one under cert-in, and from that point in time we are taking 6 hours time to report it to cert-in, and also cert-in prescribed a specific format in which that reporting need to be done.
Makes sense, Ujjwal, because the regulatory bodies have to make sure that adequate measures were taken. They cannot hold a organization responsible if they have all the things in place, and
Correct.
but they need to make sure that the effort was made. And if there is adequate reason, they can always make an exception whether it was done or not. Coming back to one of our interesting questions that we have, a gaming app that secretly transfers sensitive data is a reportable breach under cert-in.
My personal opinion is that whether it is going to be a breach or not, that is quite subject. So we need to see various other factors. The reason being the data subjects whose sensitive data are stored on that gaming app, and they have stored that, or rather they have shared that data with the gaming app under a covenant that those are not going to be misused, but it's going to be misused somehow. Yep. And this transfer is happening without their consent. So according to
Yep.
me, this appears to be a data breach.
So moving ahead. So what are reportable data breaches when it comes to cert-in? So guys, this is a read through. So these are mostly security data breaches. They can be security anomalies that you can see on your systems, your servers, your database, your VMs. So anywhere you see these activities happening, you're supposed to inform cert-in. And cert-in is an emergency response team, computer emergency response team. So they will help you out there.
We just wanted to present a live case that how our enforcement order looks like. ICO, Information Commissioner's Office, the one of the most well equipped and most revered, honored data regulator of the world. So how they issue a notice, what is the very construct of that notice, how that notice is composed. The first thing which comes to our mind, after going through the notice is this notice is a layered one. I think, or rather, it's though we are saying it's a notice, it is just like a judgment, you can say. In the Indian courts, which passes judgment, they generally, if there is a judgment, or rather, if court is passing a judgment along with the order, then in most of the cases, the judgment, that is the reasoning portion, that runs into at least 50 to 60 pages. So here you will see ICO has issued a judgment kind of thing, which has been, conveyed over a notice, but this is a layered one. If you just go down a bit, you see that just come to this left hand for more information about the revised approach. Why this revised approach? They are saying that we have taken a revised approach on reprimand. This reprimand is already there on Article 58 of the GDPR, that a supervisory authority can reprimand a body through which supposedly a data breach or any security incident had happened. And this reprimand is also a reasoned reprimand. That is, they are going to say that how we have detected the breach, what are going to be the remedial action that that entity need to take so that the breach is not repeated in future. But here, the very logic, the very reason, or the very enabling provision, which is authorizing ICO to give that reprimand, that they have added a link. This, if the the privacy professionals here, this notice is available on the net. So if you go and click this link, you will get again a 4-5 pager document. So what we find here, ICO has consciously avoided to make the order longer. So that's a very good thing. That's a very welcome thing. This is called a layered notice. Generally, this kind of layered notice or layered structure we use for the for security notices, or when we put the security notices for particularly in the company websites, we put this. But here I find that ICO has used for this kind of a judgment kind of document. They have used that kind of a layered notice structure. That's a very important and significant aspect we find.
So just one part to add. So when it comes to the UK GDPR and Information Commissioner's Office, they put their notice in public.
Correct.
So you can go to their websites and you will be able to fetch this document. This is a public document. This is publicly available, and you will be able to read the original copy. What exactly does is the content of a breach notice when it comes from the data regulation authority? Because we have been on the other side of the table when we are reporting to them, and okay, this is what has happened. Maybe we need a template to report to them, or this is a checklist that should be fulfilled. But what exactly happens when they send a notice? What, how do they explain that this has happened, and please act on it?
Correct, Rohit. So, Rohit, if we go back to the very background, that why this inquiry or the investigation was conducted by ICO, or what has ultimately necessitated for issuance of this notice, that is quite interesting. What happened? This Department of Education, they maintain students' record in a particular database. Now that database is called Learning Records Service Database. That is so LRS in short. Now, a audit done by ICO that revealed that this Department of Education, they have let another third party to access that record. What happened? That particular third party, they are the name of the third party was Trustopia. Trustopia. In fact, they have used that database. They are a screening organization, a screening company. But what they have done, they have used the students' data for the data screening they have done, just to understand whether the gambling companies are using that data. So the very original reason why the data was stored there, the very original reason why the students' data was stored in LRS, that got frustrated. Trustopia, that third party, in fact, we have, if we come to this third point, you'll see that Trustopia was in fact a screening company, which I said, and used the database for age verification, a service they offer to companies including GB Group. GB Group is a very big organization, and helped gambling companies confirm customers were over 18. So that if somebody pertaining to the database had any way got participate in some gambling thing or have anyway enrolled with the gambling organization, that can be detected. But the fact remains, this particular purpose of processing was not at all the one for which the students have given their data in the database. So that is the very object why at the time of this audit, this came to the notice of ICO, and ICO started further investigation. So this happens, we have seen, say for example, a very popular example I'm giving, this marketing optimization forms. They receive huge pool of data from the organization, they who want to contact that marketing activity, they who want to just targeting a specific customer base. Now, alongside doing that work, it also happens we find that with that volume of data, that particular marketing optimizing firm, they are training their internal AI system. So if we just go to the order again, you will find that there at page 2, they have come back with the fine. If you go to the page 2, yes. So left hand
So
side
the
you
fine is
see,
always the most interesting part
yes,
of
yes, yes. Though I'm not criticizing ICO, but here this wrap, this is also available in ICO website. That's a 4-5 pager background that they're saying that at the while determining the fine, they have taken help of this wrap. And another important aspect, I must say that in the first page you will find ICO is saying this order is based on GDPR, not UK GDPR. Okay. Now, if we go to the very particular provision of GDPR which imposes fine, that is, Article 83, we will find the very particular articles under which the fines have been imposed, or rather the enabling articles under which ICO has come to the conclusion that there had been violation of the GDPR principles of Article 5, 1A and 1F. In that it says, this 5 in case of violation of 5, it is administrative fine up to 20 million euro, or in case of undertaking and up to 4% of the total worldwide annual turnover of the preceding financial year, whichever is higher. But one thing I find here, that at the time of imposing this fine, though that has been imposed on UK sterling, but ICO has not made any further discussion that how they have arrived at this figure.
But this is a very interesting thought, Ujjwal, that how exactly are the fines calculated? Because whenever we hear of a breach or wherever we think we hear that the data protection, the regulatory authorities are acting, cracking down on some organization, we are never able to guess the fines,
In
how
fact,
that is done.
Rohit, that's a very fair point made by you. You know that whenever we are not giving some idea about how we have came to that figure, that makes the order or that makes the enforcement action vulnerable. Giving, though I was also checking the GDPR, this Article 83, whether that gives a specific specific responsibility, imposes specific responsibility on the enforcement agency to give a calculation of the philosophy how they have arrived at the that fine. I couldn't find any specific thing on that, but anyway, EDPB guideline or this kind of whatever the bodies are there, the global bodies, they come out with various guidelines on these things that may be also helpful. In fact, that would be, I'll be inviting all the privacy professionals and privacy enthusiasts here just to have further investigation on the order, that what had been this fate of this order, whether this has been further appealed, as because there had been appeal provisions under the GDPR, and that too within a particular time frame that need to be done, whether this order has been appealed or whether that wrap.
And I think so we can now go back to our side of the table. Coming
So
back to the regulation breach notification form. So this will be more like coming back to our side of the table, and how that negotiation breach notification has to be filled in and communicated to the UK authority.
yeah, so I just would like to highlight few things on this. This eIDAS is, this eIDAS stands for Electronic Identification and Trust Services. So this is something, this way of notifying breach or security incident, it is devised by ICO. This is a UK regulator. So as I was at the starting, we were saying about this, this incident response playbook. So here what we find that the regulator itself has come up and they have stated the very format in which a breach can be documented well and can be reported. In fact, we'll find that this cert-in, they have also done the same thing. They have also come up with a very composite kind of a format in which you need to fill it up. So here I would just like to say one thing, that this eIDAS refers to a range of services like that is mostly that verification of I was just before the webinar, I was just making a bit due diligence and I could find it out that that includes verification of the identity of the individuals and business online, and verifying the authenticity of electronic document, so which are very prone to data breach or a security incident.
You see that, guys, if you just read the main headings which are bolded, we can see that they have talked about infrastructure platforms when we were talking about asset types. Then the category of impact is something which we all have heard out. It's the CIA triad. Then the impact on assets, trust service concern, and the root cause they have again put it as very generic, which is easy to understand. And even in the detailed cause, they have, like as Ujjwal said, they have used very simple words. These are not legal terms. If you move ahead, then this is the explanation where they want to see what you have done as an organization to prevent it.
And
So if
here
you
I would
see,
like to make one point, Rohit, that this action, what actions have you taken? That's again very common with the GDPR approach. At the time of breach notification, GDPR categorically says again and again that what action, remedial action you have taken, that you need to articulate very properly there. So the same thing we find that here it is also resonating. It is also reiterating this eIDAS form. The UK regulator is reiterating the very same thing.
so that is a very practical of them, and I think so this can be filled in. So in case
And
you find
Rohit,
this,
I would just like to just say one thing. They have also given a helpline number. That is also very
yeah,
important. That even if you find any difficulty, the assistance is also there from ICO. That's a very
yeah.
good thing. It's a good step from ICO.
So this is there for all regulatory authorities, that they also act as advisory committees for you, for organizations, in case there is any confusion, any ambiguity with relation to interpretation of the law or processing of data. You can always contact them and they'll help you out. So with this, guys, we come to the end of our webinar, and I hope you liked it. We were able to discuss a lot about data breaches, how notifications have to be sent. Then we sat on the other side of the table, where we studied about, we dived deep down one of the notifications that was sent to Department of Education in UK, and how much they have been fined. We looked at template. Thanks everyone for joining in, and we'll conclude our webinar here. And thanks, Ujjwal, for all your views and the knowledge that you shared with us. It was great having you. I would say you added a lot of information there, and this was certainly a deep dive into one of the most notorious parts of privacy regulations. See you next time, guys. And please feel free to connect to us. Please feel free to follow Tsaaro Academy. If you want to connect with me, you can follow me on LinkedIn. You can connect me on LinkedIn. And see you next time with another webinar. Have a nice day.